Which cryptocurrency is being attacked by the SEC after XRP? How long will crypto holders believe in Ripple? How much will XRP cost in mid-2020? 3. We will answer all these questions in today's video. Ripple Chief Legal Officer Stuart Alderoty has responded to Coinbase receiving a Wells notice from the U.S. Securities and Exchange Commission, SEC. A Wells notice is a letter issued by the SEC expressing the agency's view that a corporation or person has violated securities laws. Significantly, it permits the receiver to react to these assertions in order to persuade the market regulator that they are false, with the SEC having 6 months to determine whether or not to pursue an enforcement action. Coinbase verified receipt of this letter from the SEC yesterday, but according to a blog post written by Coinbase's chief legal officer Paul Grewal, the letter provided insufficient information for Coinbase to reply to. Coinbase emphasizes that the possibility of enforcement action comes despite the fact that the SEC cleared its operation and permitted it to become a publicly listed company in April 2021, only days before SEC Chair Gary Gensler took office based on these same disclosures. Moreover, the company said that it had met with SEC authorities 30 times in the previous 9 months in order to register a component of its business and settle inquiries. Nevertheless, the SEC, which first proposed this strategy, terminated the process in January after Coinbase claimed to have spent millions of dollars in legal expenses to identify viable registration models, since none exist for cryptocurrency under the current system. According to recent reports, the cryptocurrency exchange seems to have been preparing for a clash with the regulator in recent months. As previously reported, the crypto exchange updated its risk notice to state that it may elect not to remove a listed crypto asset, even if the SEC labels it a security, barring a court judgment in favor of the regulator. In a tweet today, Alderoty seems to back the top cryptocurrency exchange, citing the old saying, "The enemy of my enemy is my friend." Moments afterwards, the Ripple Clo retweeted Grewal's answer to the SEC's Wells notice. Ripple is still embroiled in a legal battle with the market authority over whether XRP is an unregistered securities offering. Coinbase filed an amicus brief in favor of the blockchain payments company's lawsuit, which it framed as an assault on the whole young sector. According to Consensus lawyer Bill Hughes, we should expect a flood of amicus papers in favor of Coinbase if the SEC decides to pursue an enforcement action. Based on Alderoty's comments and other precedents, it would not be strange to find Ripple among Coinbase backers. Nevertheless, Hughes believes that if the SEC pursues enforcement, the prospective court fight would go for years, well beyond Gensler's rule. According to the attorney, this will most likely arise from factual disagreements, allowing it to go to appeal. In a subsequent tweet, the attorney said that supporters of a free market system would be disgusted by the SEC's actions. The future of the nascent market in the United States remains unknown. After the failures of Terra and Fox, authorities, notably the SEC, seem to have initiated an industry-wide crackdown. Market players, on the other hand, continue to ask for unambiguous market advice. The blockchain company Ripple and the Securities and Exchange Commission, SEC, seem to be nearing the end of their legal battle, according to a growing consensus in the cryptocurrency world. The case's resolution is widely anticipated to affect the future course of crypto market regulation, particularly with regard to securities categorization. As of March 27, a tweet from pro-Ripple attorney John Deaton predicted that a decision will be issued by the court within the next several weeks. If not this week, Deaton claims there is nothing to lose for XRP even if the SEC prevails, since the coin offers the best risk-reward. But he said that if Ripple prevails, the fact that XRP is not a security would be established, and the token's value will rise. According to Fox Business, attorneys involved in the case have hinted that the legal conflict might terminate in the next days, thus increasing the likelihood of the summary judgment date. Deaton has encouraged the crypto community to see the lawsuit as an assault on the whole digital asset market and not just a Ripple problem, since he expects the contentious Heinemann speech emails will be opened on the basis of being judicial records. On March 23, defense attorney James Phelan tweeted that the SEC had sent its answer to the defendants in Ripple's letters requesting permission to rely on Bittner and Voyager as additional authority. According to the SEC's reaction, the letter included random thoughts, excerpts from the judge's concurring judgment in the Bittner case, and an order confirming the bankruptcy plan in the Voyager case. However, the regulator said that the extracts do not give any grounds to reject the SEC's move for summary judgment, despite the defendants' claims that they bolster their fair notice position. The SEC's answer to the Bittner case raises some fair concerns, Ripple supporter and lawyer Jeremy Hogan argues. But the regulator's effort to argue against the Voyager judge's finding on the perceived uncertainties of the crypto realm is smirkable. The answer, he said, renders the Bittner judgment moot, but the Voyager judge's judgment is still in effect for Ripple. Both sides are convinced they will prevail in court, so a settlement is a significant development. Bill Morgan, an attorney from Australia, said that all chance of a settlement was eliminated after seeing the SEC's response letter. In the ongoing legal battle between Ripple and the United States Securities and Exchange Commission, the SEC has submitted a response to Ripple's claim citing prior cases and their conclusions that may have an effect on the cryptocurrency business. According to a tweet posted by U.S. Defense Counsel James K. Phelan on March 23, the SEC has delivered its answer to the two letters seeking additional authority from the bankruptcy case of Bitcoin lending platform Voyager Digital and the Bittner v. Digital and the Bittner v. United States lawsuit. As part of its fair notice defense, Ripple had previously filed the ruling in the Voyager bankruptcy case, citing Judge Micah Wiles' comments on the significant uncertainties in the cryptocurrency industry, on which regulators themselves cannot seem to agree. The second letter addresses the case of Bittner v. United States, whereby a U.S.-born citizen of Romanian descent neglected to declare all of his income to the Internal Revenue Service. Fair notice should be provided to the public in terms that the common world will comprehend of what the law plans to do if a specific boundary is crossed, the court said. The SEC has responded to the defendants' letters, claiming that the reasons raised in them do not constitute a valid fair notice defense and that neither offers any basis to reject the SEC's petition for summary judgment. The SEC has moved for summary judgment, and the defendants have sent letters citing stray words from two instances in objection. Defendants argue that these passages buttress their fair notice position, but none of them is correct. The SEC's legal team argued that the court's decision in Bittner, which addressed whether penalties could be imposed once for each unreported foreign bank account or as a single fine, supported its position that a single penalty could be imposed for the transgression under the rule of lenity, but did not imply that the rule could be used to escape liability. Summary judgments, a settlement between the parties, and a follow-up litigation exploring whether any XRP token sales in the U.S. contained an unregistered investment contract are all possible outcomes previously cited by former attorney and Evernode XRP co-founder Scott Chamberlain. Judge Analisa Torres issued an initial 57-page ruling in which both the blockchain company and the financial regulator were seeking to exclude expert testimonies from summary judgment, and his recommendations came after what he believed to be a major win for Ripple against the SEC with the fatal exclusion of one specific witness.